Comments apart, justifications apart, let us see what are those positive things that have emerged out of this judicial innovation, which was not there in the text, but in the context the courts have innovated upon, as we have seen some of the examples. And to put it within courts activism, what are the positive things in it? I must say, at the very outset, there is a dramatic transformation of the form and substance of the law. The law has come alive. It has impacted the very characterization of individual and collective rights and procedures established by law and practice in accessing them. See, law is nothing except something put in black and white, lying on a piece of paper. It comes alive when it is made to work, when it is activated, and that activation the courts of law have done. They, without doubt, have created the ground for evolution of new rights, crystallized principles, and approaches to access and secure them, and environment happened to be the muse through which the music of environmental justice was played by the higher judiciary. Let me give a few illustrative examples. One is elevating environmental problems to the status of violation of fundamental rights. The first and the foremost things that the courts of law have done is to relate environmental problems to a violation of fundamental right. A very clever move, a very strategic measure by the courts of law, because we understand the language of fundamental rights. Constitution speaks the language of fundamental rights. It speaks about right to life, right to equality, freedoms, freedom of movement, freedom of speech, freedom of expression. So primarily it is individualized or even collective rights. So it is a rights language law knows, people know, administration knows, lawmaker knows. So let us speak in that language and relate environmental problems to that this right gets violated if this particular environmental problem persists. Okay, understanding of language is all right, but why do you do that? Why you take that strain? For the simple reason that there are ample provision for the protection of our rights, fundamental, basic, inalienable rights. And there is a constitutional guarantee that at any cost, even against the government, you can exercise this right. And here we had a problem that the Constitution does not speak the language of the environment. Please remember, the Constitution was inaugurated in 1949. All the provisions came into force in 1950. And at that time, we did not have this environmental crisis in our mind. And even the amendment that came to the Constitution, incorporating the environmental right, duty, and obligation, was through the 42nd Amendment more than 25 years after the Constitution was inaugurated. As such, there is no direct articulation of right to environment under the Constitution. We have discussed it in an earlier module, so let me not repeat. So the impact concerning environment, protection and insulation of protection as it is available for any fundamental right was very much necessary, and that's why the bond and link between environmental concerns and human rights or fundamental rights was a dire necessity, and that's what the court did to ensure protection from any legislative prescription or an administrative fiat leading to its violation. Let us have an example. There was this effort of a municipal corporation. This is commonplace. This is happening all around. and try to relate that reality with this particular case, then perhaps you will be able to appreciate and understand. Here is a municipal corporation which wanted to convert a land earmarked for a residential park into building a housing complex. Look at that. Residential park is for public purpose, housing complex for those who are in need of houses. So both are public purposes. But what did the court do? The High Court in Andhra Pradesh thwarted such a kind of a measure on the part of the municipal corporation by holding that such a conversion would tantamount to the violation of the fundamental right to live in a well-planned, hygienic environment. The case is T. Damodar Rao versus the Municipal Corporation of Hyderabad. The courts expanded not just the linkage between environmental concerns of retaining a particular ecosystem like a public park as closely related to the ability and the opportunity for the civilians to have fresh air, breathe easy, repose and recreation, and which is a quality of life, a fundamental right guaranteed. So link those two. Protect the ecosystem and ensure human rights manifestation in its full form. But the other innovation was not only they anchored environmental concern to human rights, even they expanded the human right notion itself. They just used human rights as a vehicle to drive home the point of a close nexus between protection of environment and human rights as inseparable, irretrievable, and one feeds to the other, one leads to the other, one comes alive with the other one, and not in isolation. This happened in the Center for Environmental Law versus State of Orissa case. It's a 1998 decision in which the court issued a number of instructions for the conservation of a Bhitarkarnika wildlife sanctuary. Now it's a national park. And this was considered to be an imperative need because a particular developmental activity was planned by the government for which a part of the Bhitarkarnika wildlife sanctuary was at some point to be encroached upon, in some places would be threatened. So what did the court say? It gave instructions. These are the safeguard measures that you should have. We are not coming in the way of the developmental activity. You can carry it out. But have you made provision? And if you have not do that, these are the safeguards that you should put in place so that this particular conservation area, a wildlife sanctuary which became a national park later, we know that this is a developmental activity that you would like to have because of certain close proximity with the sea and which would facilitate a particular dockyard to be built, and for movement of traffic and movement of goods it's necessary. Even if it is for public interest, the other public interest is also this, and this should be first taken care of while you address the other one. Or there was other case, it's called as the public case, PUBLIC case, People United for Better Living in Kolkata versus State of West Bengal. It's a 1993 decision of the Kolkata High Court. What happened? Here was a move on the part of the government to establish a huge structure, World Trade Center. We all know World Trade Center is a hub of economic activity, not just within a particular state or a region, not just confined to India, but it has international ramifications. So something of very great public interest. So nothing wrong in setting up of a World Trade Center. But where do you locate that? That was the issue. This was supposed to be located on a wetland. In one of the earlier modules, we have also seen what is a wetland, what is importance and significance. Here the wetland was the Salt Lake City, Salt Lake area, a huge area, a wetland. On that, bang in the middle of it, the World Trade Center was to come. The court said, nothing doing. We have no problems in you establishing a World Trade Center, but decide on the location, taking into consideration the environmental implications on a particular ecosystem which is fragile, which needs protection. The court felt such a move would adversely impact the integrity of this very special ecosystem, and so we will not allow that. It was not just individual human rights, or it is not just a particular ecosystem conservation which was the focus of the court of law. Look at the tool of fundamental right being employed to give a wider ambit of application in relation to not just human rights but also of environmental right, recognition of customary rights of people, environment friendly activities of communities which have been practiced by traditional communities should be nurtured and protected, and these traditional practices of communities should never ever be trumped at the altar of bringing in new technology, their application, which may bring in a lot of economic good, but ecologically ruinous and in clear violation of rights of communities. Where did the court of law say this? It said that in a series of cases concerning aquaculture, or what you refer to as the prawn culture, the aquaculture cases, which we have discussed under the CRZ law. Please refer to that, where the customary rights of the people in carrying out an aqua farming exercise protected, but not the modern aquaculture projects not favored by the court of law. Diversion of a common grazing land for the purpose of building low-cost houses for the benefit of underprivileged sections of society was stalled by the Gujarat High Court in the year 1995 in the case of Nabipur Gram Panchayat versus State of Gujarat. Here is a particular ecosystem, the common grazing land, which is meant to perform certain ecological functions and also to take care of certain kinds of livelihood interest of communities of people, should not be sacrificed at the altar of the expediency of a space for another public purpose. You cannot actually undermine one human right to promote another human right. That's the essence of it, but with the result that the common grazing land got protected. Look at the innovation. It also happened in Uttar Pradesh, in the Om Prakash Bhatt versus State of Uttar Pradesh, a judgment of Allahabad High Court in 1997. Here was an effort on the part of the state government in transforming huge tracts. Is it an ordinary land? No. Meadows and pasture lands in the Gadwal region. Gadwal region at that time was under the undivided Uttar Pradesh. Now it is in Uttarakhand. So I am referring to a 1997 case. And in the Gadwal region, when these meadows and pasture lands were to be transformed into resorts, tourism centers, with the argument that it would boost the economy, it would promote tourism and give great employment opportunities for the people, the court did not agree with that. What are you doing? You have to do all this of boosting economy, promote tourism, improve economic opportunities. We are not coming in the way. But where? Is it the place which is boasting of a very unique, internationally renowned ecosystem, the Himalayan meadows and pasture lands? This is not only fragile, this is not only something which is prone to any kind of seismic activity, which is any developmental activity would be ruinous, but it is a unique Himalayan ecosystem, and it is an ecosystem which also caters to the protection of the traditional communitarian practice and the right of grazing livestock. You are putting it at great jeopardy, all this, just for a few economic gains. We do not allow this. Or take the measure of the court of law in protecting the interests of tribals and conserving forests. How did the courts go about it? The courts, in a series of cases, successfully carried out an exercise of harmonizing the interest of forest dwelling community with that of the concerns of conservation of forests. I make a special reference to this because the cases that I am going to refer now were enacted before the year 2006. Because in 2006, we have seen in an earlier module in our discussion, the Forest Right Act was passed. So the rights of the forest dwellers were recognized and protected through a new law made in 2006. Till then, there was no legislative enactment protecting the rights of the forest dwellers. So there was a vacuum in the law. And so those forest dwelling community did not have a clear right of residence there. Legally, legislatively protected. The court had to come to their aid. And what was the practice of these communities of people? And I'm referring to the forest dwelling tribal community here. It was to obtain bamboo and earn a livelihood for themselves. What were they doing? These were minor forest produce. For centuries, they were engaged in this activity as something as a source of livelihood. From bamboo, they would create articles, sell it in the market, earn a livelihood for themselves. This is what they were doing. What did the government do in this particular case? The government attempted to render this not possible. This practice of taking out the articles from the forest to sell it outside, we don't permit. It's a forest property, a minor forest produce. It has to be used. Whether you want to sell it, you want to consume it, you do it within it. We allow that. But it cannot be taken out of the forest. So they issued an order. You cannot transport these from out of the forest area. Actually, this measure the forest department took mainly for the purpose, as it was alleged, that these forest dwellers, when they have this right of using the minor forest produce, let them use it within the forest area, consume it if they want, because they want to live, let them live with that. But if they want to sell anything including the bamboo or the products, let them sell it within the forest. Arre, come on, who are there in the forest to buy things from them? They have to go out to the outside world where there is a market for that, and people will buy from them. Oh, no, 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 no. Why? There are forest contractors here. They're ready to buy your bamboo. Oh, actually, the idea was with license from the forest department, because the local paper mill obtained that license to collect bamboo in the forest area. So a contract for taking bamboo out of the forest to be supplied to the local paper mill the deal was struck between the forest department and the paper mill. To facilitate that, these tribals were coming in the way because they had a claim over the bamboo. They wanted to make articles out of it and sell it in the market, and all that the forest department did was to stop that without saying or claiming to have stopped the traditional practice. But it was actually intended for that purpose. Here, in a landmark judgment given by the Gujarat High Court in 1987, the case is Fateh Singh Gimba Wasawa versus State of Gujarat. The forest department was ordered by the court not to interfere in the transit of bamboo articles under these circumstances from the forest to non-forest areas. See, if the government acts in a way which is even violating a statutory provision through various executive orders, if it is in a civilian area where civilized people exist, as they claim, people who are in the know of law or who are in the know of way of life, defending themselves and protecting their interest is possible. They can go to court. But what about those people who are living in the forest for whom certain protections are given in law? Ignoring that or in violation of that, certain orders are issued by the government. Yes, governments have issued orders like that. Where it happened? It happened in one particular case where in a forest area, the government got into an arrangement with a particular industry for felling trees in a particular patch of forest land and transporting it out of the forest area for business purposes. What's the problem here? Is it not something which is within the powers of the forest department to decide on which tree to be cut, which tree to be transported, and which agency of the forest department to act on that in dealing with timber? Well, they have the power. Then what is the objection here? The objection is that there is a law that within the forest area, if there are tribals living there and there is a tribal land within that forest area, and this is a law in Andhra Pradesh state, and this has been the law with so many other states also. Most of the states have this kind of a law. A tribal land is inalienable, non-transferable, cannot be converted into something else to deny the tribals of their right over that. Even tribals cannot sell that land. They can inherit. They have the right of inheritance, but no right of alienation, no right of selling it. Huh. The idea is, this is one community which is dependent on this resource to keep up their identity. As part of their identity, their relationship with this land is respected, and so law is made. State government makes the law. AP government had made this law. The case is Shankar Reddy versus State of Andhra Pradesh. What did the court say? The court struck down a government order that permitted felling of trees and transport of timber from the forest area, which was in clear contravention of the law concerning tribal lands. What is the reasoning of the court here? The same as I gave you. The statutory provisions were intended to safeguard the interests of the scheduled tribes and to preserve forest land. The executive order was in clear violation of this. So, right of the scheduled tribes and preservation of the forest were integral to each other. That's what the court said. We have also seen in one of our earlier discussions as to how this expansion of right to environment was achieved by the court by promoting right to environmental information. Please refer to the earlier module on the subject, where the right to access relevant and authentic information is a very crucial aspect of good environmental governance, because this enables one to know and understand about the kind of impact any activity would have on his environment, besides forewarning about the impacts any activity would have on his environment, forewarns about mishaps, helps in taking precautionary measures, and facilitating participation in the process of environmental planning and decision making. I don't think any further explanation is required than this, and details are there in the earlier module which we have discussed. Please refer to that. See, having a right is no doubt important. In realizing the right, there are several procedures laid down in the law. Many a time, the one who has the right to know about that right itself is a difficult thing in law. Many of us are unaware of what kind of rights that we have. Forget about how we are going to realize these rights. When such is the state of affairs in a country like India, even in cities, I will tell you, the level of ignorance is of that level, where knowing about right is itself as a problem. What are the categories and catalog of rights that I have? Not very conversant. And at the same time, how to realize these rights, what are the means, mechanisms and procedures I should follow? Very difficult to follow unless you are a lawyer or somebody who is in the know of law. So in such cases, how do one access justice for violation of one's rights? And it is all the more so, more difficult in the case of environment, which unlike a human being does not know, cannot also prosecute its own claim, let alone know the procedures. And whoever who wants to protect environment, you cannot expect him to know all the procedures as to how to access courts of law and secure justice. Amazing ability is what you have to give when the merit is due for the higher judiciary in demystifying this law and its processes by relaxing procedures as to empower the affected, aggrieved and concerned entities, especially in relation to environment, to ventilate their points of view in the judicial forum and secure justice. You are familiar with this particular case, how that procedure was relaxed. To approach a high court or a supreme court, what you should do? You should submit a petition detailing out where exactly is the problem, who is causing the problem, who is responsible for this, and how it is happening, and why the environment is bleeding, all that. So to go to the High Court or the Supreme Court, even through a writ jurisdiction, you have to follow certain procedures. Of course, you don't have to pay any fee because it is in public interest. But what is the procedure? See, I am an activist group. I would like to bring in an action, but I just don't have the means, methods, and mechanisms as to how to realize the right of the environment. And which is that environment? It is the Doon Valley, which is bleeding because of illegal mining activity that is going on. Please refer to this case. We discussed a case decided by the Supreme Court in 1985. In an earlier module, we had discussed that, which deals with environmental rights. What is the device employed by the court? All that this gentleman, Avadash Kaushal, the chairperson of the Rural Litigation and Entitlement Kendra, did was wrote a postcard and posted it to, it was addressed to whom? Posted it to the addressee by name, the Chief Justice of India, the Supreme Court. And what did the Supreme Court do? It received it and elevated it to a public interest litigation petition. Relax the procedure because people may not know things. Procedures are important, all right, but they are not everything. They are just a means to achieve a goal. The substantive part of the law is important. The substance is environment is suffering. Some action is required. Can the court help? That was the thing. Court came to the aid. It was a knight in shining armory to help the underprivileged, the voiceless, the environment of the Dehradun Valley. It also did something more. It broad-based environmental administration. What did court do? Supreme Court categorically asserted that it was impossible for a single authority, a governmental institution, exclusively and effectively control environmental damage. See, environment is everywhere. Environmental problems are everywhere. The governmental machinery is small. Its personnel are very few. They cannot fan out to every nook and corner of India to see what violations take place and how they are happening. The best protection for environment is possible if people are engaged. They are best protected by the people themselves. And the governmental agencies should seek and secure the assistance of voluntary groups in this regard. Who said this? The Supreme Court of India. When was that? In the year 1996. In which case, Indian Council for Environmental Legal Action versus Union of India. The gateway, if at all there was any wall or an iron curtain that was there, preventing the government approaching people to engage them in consultation, to involve them in execution, to act as the eyes and ears of the government in reporting about environmental violations. The gates were thrown wide open by this kind of a decision given by the highest court of law, which made environmental administration as not strictly exclusively confined to the agencies of state specially designed to take care of different sectors of environment. Where is the constitutional provision for that? Please recall what we discussed earlier. There is Article 51A, capital A, clause G, which makes it a duty of every citizen of India to maintain, protect and care for environment and aid and assist the state whenever required, and that is precisely what the court amplified in this particular case. It evolved new principles of environmental governance. We already know about that, we have discussed it earlier, or even added a lot of gloss to the principle of polluter pays, sustainable development, the principle of precaution, and public trust doctrine. Especially the public trust doctrine is our Indian contribution. Please read the cases of Kamal Nath case of 1996 Supreme Court vintage. Also read the 2G spectrum case of 2012 of the Supreme Court, which we discussed in great detail in an earlier module, which is supposed to be Indian contribution to environmental jurisprudence the world over on public trust doctrine. Or even with regard to principle of precaution, while the principle of precaution only said anticipation, avoidance, attack, and look for alternatives as the four components of principle of precaution, Indian court supplied the fifth element, that scientific uncertainty is no excuse in taking action of ensuring that one would not get into a particular kind of an activity, including a developmental activity, when science is not sure about the likely impact of that activity. Let science make it certain, then you can proceed further. So like that, the courts have been able to bring in human rights, expanded on these notions, and through that it was able to act as a sentinel, guardian and protector of the environment and ensure better and more effective environmental governance.